Welcome back to the KLF Deep Dive. I'm here with Phyllis Marcus. You've seen her before. She was on here with us, I want to say a couple of weeks ago, and she was kind enough to talk to us about her perspective from the NAD. She works with the NAD. She does not necessarily represent the NAD. I just want to be clear about that. Neither of us is giving legal advice. However, this is supposed to be educational. Phyllis, tell us a little bit about you.
Well, I am the Vice President of the National Advertising Division at BBB National Program. So I do work directly with the NAD, but you're right, Darshan, that today the views that you and I will be expressing are our own, because I'm sure we'll go down certain paths, surmise certain things, and kind of unpack other things. I previously was a law firm partner for a decade, and before that, I spent almost 2 decades at the Federal Trade Commission doing consumer protection enforcement and regulatory work.
Let me ask you a really simple question, because you use the word consumer, which is very interesting to me, because do you see, from your perspective, from the vantage point of being at the NAD, that the FDA and the FTC are looking at the needs of consumers, and the word consumer implies a sort of end user who decides what product they buy. So is it still consumer, or is there a different balance you look at? How does that kind of, from your vantage point, how does that make sense?
So I can answer this question in 2 ways.
Okay.
Who is a consumer is
Okay.
not solely the end layperson on the street. And we at the NAD have a number of cases where we look at the relevant consuming audience, and healthcare practitioners can be one of the relevant consuming audiences. In addition, based on newer advertising techniques, and soon enough, we're not even going to be able to say that digital advertising is so new, but with the proliferation of digital advertising, lay consumers are likely to see advertising messages, even if the original intended audience was a set of professionals. So when companies put messaging on their websites, for example, or use social media to disseminate messages, the broader consuming public is ingesting that information. And they aren't just cabining their exposure to the commercials that people see on TV that are intended, only for the end user. So that's a long answer to the consuming public. We can protect and look at healthcare professionals as one consuming public, and we can look at the broad array of materials in making our determinations in protecting regular consumers.
How do you reconcile those two when you're saying, as is reality, that patients or lay consumers will access both?
Well, perhaps one of the links is in looking at what is then communicated from healthcare practitioners down to the public for whom a particular medication is being prescribed. So if the messaging that is coming from a company is potentially deceptive or misleading, and then it is being passed along to consumers, that is problematic. And so we have not shied away from challenges that have been brought before us where a portion of the advertising assets are directed to healthcare practitioners. I'll give you an example. We had a pair of cases, challenges brought by Sanofi against Galderma for Galderma's marketing of an eczema drug called Nemluvia. And the 2 cases involved slightly different claims and different mechanisms of advertising. So the first case, which I'll call Nemluvia 1, involved website advertising, direct to public, and assets directed to healthcare practitioners. We did not say that the healthcare practitioner advertising was off limits for our consideration. and I apologize if you guys see my camera moving up, I'm putting it back down. Now, the second case, Nemluvia 2, involved solely a commercial. And so that was direct to consumer advertising. Again, same product, same two companies bringing the challenges, different advertising media, same analysis brought by us. To be honest with you, what we're missing in this discussion is the reality of how communications to healthcare practitioners make it into the marketplace. They also are available online.
Well,
And
how
so
do you mean?
you can search. There are websites, and they are accessible to the viewing public as well. And so you're right, we are not parsing these two things.
Enjoying our content? We'd love to hear more. Please like, comment, share, and find more.
Now, I'll turn the tables on you
Please.
and ask, in the FDA context, then, how is the FDA viewing those same materials?
So it's not just the FDA, it's also the DOJ, right? Because technically OIG.
Right.
But the FDA will generally comment on and they'll discuss claims made in direct-to-patient stuff. They will not typically get into direct to physicians as much. On the other hand, you will see settlements from OIG that involve physicians because physicians have then have switched their roles. So in those cases, the DOJ takes the position that you weren't acting as a physician in that role. You were acting as a salesperson. You just happened to wear a white coat. So that's how that distinction has been parsed. There are guidances from the FDA, for example, the SIUU guidance, and which is the scientific exchange guidance. And then there's the one called the CFL, or the consistent with the label guidance, which do get into it. There's a whole bunch of discussion about whether that applies in the context of actual HCP communications, because the question is, can the government regulate that in the same way? Because that goes into, again, First Amendment discussions. So I might argue that that is still a sales discussion and how to do it properly, because the FDA has lost a bunch of court cases starting from about 2012 on the regulation of this type of discussion. So it's a very interesting, nuanced argument, and I think a lot of people, and I know practitioners who disagree on exactly this point. So,
well, and I will tell you, our role is different. We are not a government entity. We are an independent, not-for-profit, self-regulatory organization. And so some of those constraints that you're describing do not apply.
Let me ask you this. So when you're in a position where you are helping guide companies who are saying, no, this is HCP versus non-HCP, how do you begin to explain to companies that I don't care? It's a different audience. We're not an agency.
So we are not a guidance offering body. We are adjudicators, essentially, of disputes between companies. And so part of the answer is an easy answer. I'm not developing guidance except in the context of the cases that we issue and the decisions that we draft. And so from the viewing public that is familiar with the body of cases that we've issued at the NAD, a discerning reader will see that certain of our cases will involve advertising statements made to healthcare practitioners. Parties do have an ability to make jurisdictional arguments before us, but our criteria is that the claim or claims have to be national in nature and advertising in nature. And so if they pass muster, they are both national and they are advertising, we will review them.
But what constitutes advertising in that situation?
Well, I'm not, because you and I are talking, I'm
Yes,
not going to pull up the document right
please
now,
don't.
but we do have a definition of what is advertising. And so, I'm not in private practice any longer. If I were, those questions would be brought to me by clients. And we would talk through them. But we're serving a different role at the NAD, and I'm thankful then that I don't have to answer some of these questions that you're bringing.
Fair enough. I.e., you need to go subscribe to the NAD database, find out a little bit more.
And for those listeners, and I may have said this in our last discussion, but it can't be said enough. If you want to understand what is happening in the world of advertising, subscribe to our press releases, and if you've got the means to do it, I would say become a paying subscriber to our online archive. It is a treasure trove going back decades of our written decisions. There are easy ways to search and find those decisions, and you can see really in-depth analysis about how we make our recommendations and determinations. So that's my plug.
Now, let me ask you a burgeoning area that people are playing around with and are trying to understand how to analyze this. The standards that the FDA uses for a compounding pharmacy, and one might argue they don't have the same jurisdiction because the FTC does, not the FDA, because of the whole prescription thing. Is that different? And what is the FTC's jurisdiction? Because we all know about that intercompany memo, which outlined their jurisdiction.
The agreement that you're talking about is from the 1970s, if I'm not mistaken.
I think that's about right.
And it's a memorandum of understanding between the FDA and the FTC, and it's long been in place. And the FTC has other MOUs with other agencies where there's overlap. And so the two agencies kind of divided up the world at the time. And the FTC took over-the-counter labeling and advertising, and the FDA took prescription drug labeling and advertising. And I believe that split remains. Now, when the NAD gets involved, and we have gotten involved in prescription drug advertising, so our jurisdiction is different than the FTC's jurisdiction. We're not an agency, we're an organization, and non-governmental at that.
So what does the word discontinue claims mean in this case?
So we expect permanent discontinuance of the claims that were in the challenge. And so it sounds kind of formulaic and rigid, but the challenger submits a complaint to us. We don't go out and find other potentially problematic claims. So it is up to the challenger to identify the claims that they want us to review. The target of the challenge has the option of saying, we're looking at these claims and we're going to permanently discontinue them. A party can agree to adhere to our recommendation, which is keep the claim in the marketplace because you've substantiated it, modify the claim in some way because we think it can be modified, or discontinue the claim because it cannot be made it cannot be made in a truthful and non-deceptive manner. So it's these claims, this recommendation, and we match them up. We don't have any more expansive power to say, and don't make any health-related claims in the marketplace, or don't make any other claims relating to this product and its efficacy. We just look at what was brought before us in the complaint and judge those claims.
So interesting to me because I'm thinking of like 15. I've been writing notes down, as you can tell, and I have like a bunch of questions. But at the end of it, is there like a settlement agreement or a order, or how do you put down
So
the final recommendation?
now we get technical. For those of you who want to go access our online archive as subscribers, you'll see this. I mean, we have a format in which we write our decisions. We set forth who the parties are. We describe what the claims are that have been identified that are the subject of the challenge. And we go item by item or bucket by bucket, and we analyze them based on the substantiation and the arguments that the advertiser has presented to us, and whether there are any counter arguments presented by the challenger. So in each section of our decision, we will make a recommendation as to that bucket of claims. And as I said, it's either that we found that those claims can be substantiated and they should remain, or the claims need to be modified or discontinued. At the end of our decision, we summarize all of those recommendations. So if you were only reading one part of the decision, rip off the conclusion and take that as your guide sheet. Now, advertisers have the opportunity to submit, and it is part of the written decision, what we call an advertiser statement. So in that advertiser statement, the advertiser is required to say right off the bat, at the beginning of that advertiser statement, they may say, while we heartily disagree, we will comply. Or we can't live with this, and therefore we will not comply. So we require the advertiser to state right at the outset what they're going to do with our recommendations. We then say, as a result of the advertiser's decision not to comply, we will be referring this case to the appropriate regulatory or oversight agencies. And in the case of digital media, we also refer to the platforms on which the advertising has appeared. So there's not a settlement agreement per se, but the advertiser is required to state whether they will adhere to our recommendations or not. Now, these the NAD decisions and our recommendations are not enforceable by law. They don't carry the same power that, for example, an agreement of voluntary compliance might, or a consent order or decree coming out of one of the agencies. Again, we're an independent, not-for-profit, voluntary, self-regulatory organization.
A campaign can be 2 months long, and then they're moving and shifting, and someone comes in and says discontinue. That was 3 claims. That was 3 ads ago, or 3 programs ago. How does the NAD combat this issue of they're just moving too quickly? And go ahead.
Yeah. So we're reviewing claims, and the claims come in the context of ads. But even if an ad comes down, our analysis applies to the claim. So if the same claim appears, even in a different form, new media campaign, new month, that claim will be the subject of our decision.
Can a company, for example, a pharmaceutical company, go to court with this and go, hey, FDA, and you guys might refer them, would the FDA use this as the basis of misbranding or not quite?
So it's possible. We refer so that the regulatory agencies can consider under their own statutory and regulatory authority whether the advertising at issue violates those laws. Court now take action under our authority on the basis of the NAD's analysis. I'll give you an example of a somewhat recent case that where the fact of the NAD's determinations was cited as a part of a regulatory authority's determination to bring a lawsuit. Several years ago, we entertained a challenge involving JBS, the major meat processor, and we determined that their claims relating to net zero achievement, and I believe that the claim was net zero by 2040, that the company did not have a substantiable basis for making those claims and an actionable plan to get there. Now, subsequently, the New York Attorney General brought suit against JBS. And the NAD's action was raised in the recitation of facts in the complaint. So not the causes of action section, but in the factual part of the complaint. And so that is an example of where our action has led to formal enforcement action.
Follow our page on LinkedIn.
I first of all, I agree with you, but I'm actually thinking about two scenarios. So the first one is, I think you guys actually NAD had a settlement involving two pharma companies who were battling over the same claim. I forget which companies they were. But it was interesting because I think you guys came out and said, in one version, the consumer version is not okay, but the HCP version is. But the interesting part was the FDA then came out and said, we don't find either of these to be acceptable, and we're going to do it again. I wonder if that was part of the basis, saying we can't depend on the NAD, but this is our independent assessment.
So that can happen as well. There is an independent analysis that occurs. We do try to conform. The application of the laws is not because it's NAD created. I mean, if there is regulatory guidance, if there is a regulation that applies, we will borrow from that to our analysis. Do they always align? It's possible that they don't, or that one or the other of us is viewed as more or less lenient in the particular context.
As usual, Phyllis, we'd love to have you back again. And this was amazing. How can people reach you or the NAD if you have questions? And we'll put that in the show notes as well.
Sure. Well, my email is pmarcus@bbbnp.org. We have a wonderfully accessible website, bbbnp.org, I believe, is our website. You will find a host of information, both about the National Advertising Division, but about all of the self-regulatory programs that we administer at the organization. There's links to our procedures. You can find our press releases, our annual report, and if you're so inclined and you're ready, there is a link to how to file a challenge before us.
Phyllis, thank you so much for coming on. This was an absolute pleasure. And I'm sure we'll see you again soon.
Sounds good.
Call, click, or email.